Hello, I'm John Mowbray. I'm a partner in the real estate dispute resolution team at IBB. Well, I'm pleased to say that we're seeing our developer clients increasingly active in the market. They're out there, they're buying sites and they're putting forward schemes, particularly mixed-use residential schemes. But sometimes issues will arise on a site. For example, an adjoining owner may claim to have the benefit of a right of relied. There may be a restrictive covenant imposed on the site, which could frustrate development. And also, sometimes it's necessary to secure vacant possession of the site, whether it be from residential or commercial occupiers. Yes, the concern for developers is that they may be on the end of an injunction, whether that be stopping them getting their scheme off the ground in the first place, or having started or even completed the build, an order compelling them to remove part of that development so that it doesn't interfere with the neighbour's right of light. Now, undoubtedly, this concern was heightened by the 2010 High Court decision in the case of Heaney. In that case, the judge ordered that a substantial part of a new commercial building be removed because it interfered with light enjoyed by a neighbouring property. Now, this decision came as a surprise to many commentators because the thrust of decisions previously had seemed to be moving, in the context of commercial property anyway, towards damages being awarded rather than an injunction. So where this decision left developers was the real fear that they could be very much ransomed by neighbouring owners and have to pay really quite a significant sum in order to secure a release of the right of light. Well, fortunately, in March 2014, in the case of Lawrence and Coventry, the Supreme Court considered the issue of whether damages should be ordered rather than an injunction. Now, although this wasn't a right of light case, the Supreme Court undoubtedly had in mind cases such as Heaney, and very much felt that the law had taken a bit of a wrong turn, and a much more flexible approach needed to be taken by the courts towards the issue of whether damages should be awarded rather than an injunction. Now, this is undoubtedly a boost for developers, but it still should be said there is still a danger of an injunction, and they will be well advised to get joined-up advice at the outset from both the rights of light surveyor and a lawyer to come up with the best strategy for clearing off this issue. Yes, certainly the Lawrence and Coventry case is relevant to any property right where a party is seeking to get an injunction, and that would include a restrictive covenant. And that's very much one of the issues we would want to consider with a client. But I think our first issue would be whether or not the restrictive covenant is even enforceable. And there may be a number of technical reasons where it may not be. As a result, we may wish to make an application to the court for a declaration as to its enforceability. If it is enforceable, then another issue to consider is the merits of making an application to the upper tribunal, property chamber, for a discharge or a modification of the covenant. Now, particularly if the covenant is quite old, and or if the development site has the benefit of planning permission, the prospects of success of an application may be quite good. No, I think the first point to make is that insurance may well be available for the developer in order to cover off the risk, whether that be rights of light, restrictive covenants, or other title issues. With our experience of dealing with matters when they do become contentious, we will be able to review a draft insurance policy with a view to making sure it's as robust and comprehensive as possible. I think the other point to make is that we do recognise that litigation is an unwelcome distraction from a client's key business, core business. As a result, we look very much to work with the client and its other advisors to seek the optimum resolution of the dispute. Now, sometimes litigation may be an important weapon in the client's armoury. Other times it may be inevitable because of the attitude of the opposing party. But I think it should be said that most cases do settle and are resolved without the need for court proceedings, or certainly without the need for a full trial. And I think the key to that is a focus right at the outset on the key issues, an analysis of the client's strong points, and then looking to promote those as strongly as possible. If you would like to discuss any of these issues or related matters, please contact me, John Mowbray, at IBB Solicitors.